You have questions, we have answers. This is Jane Miller.
And this is Ken Miller. Welcome to our show, all about real estate with Ken and Jane. Today we have as our guest Larry Kroll, a partner with SGK Legal, located in East Brunswick, New Jersey. Larry,
Thank you. Good morning.
Big welcome to our show.
Welcome.
And first and foremost, we like to recognize and thank you for being a strong supporter of the East Brunswick Regional Chamber of Commerce. You're always supporting all the events. Yeah, and we want to recognize and acknowledge that.
Thank you. Likewise, you're also a very strong supporter of the Chamber.
Yeah, and also you've been not only a supporter, but you've been an officer, an executive officer for a number of years as, I believe, the treasurer, if my memory. So you've done a lot of volunteer work, and that's highly appreciated.
And give back to the community.
Thank you.
Yeah, thank you.
Yeah.
I know Larry for a long time ago. I have to tell you, right? I still remembered, I don't know how, right, all these details. 16 years ago, I did my closing. I mean, pretty early stage in my career. I did a closing in your office. And that time, Mary that time still worked there. I remember she had a cast on her leg. She couldn't even walk. She was hopping. And then when she has to need your guys to come sign something, we did a closing there. That's my memory. That's like a 15 years ago.
Well,
yeah.
Well, we did real estate then. We still do real estate.
Yeah,
that's right.
Well, let's lead right into it.
And I still work with Mary.
Yeah, I do know.
Let's just talk about just give an overview of your firm and, of course, your contact information so our listeners can get in touch with you if they need your legal services.
My firm, SGK Legal, is a New Jersey firm. We're located in East Brunswick, and we focus on the needs of individuals and small business. Real estate is a big part of what we do, both residential and commercial. Mm-hmm. And we also handle other real estate matters such as landlord-tenant disputes, estate planning, which dovetails into real estate, commercial business transactions, which frequently also involve real estate, and real estate litigation when that becomes appropriate. One of the advantages of working with us is that when you work with a smaller firm, you typically deal directly with the attorney, as opposed to being passed around.
Yeah.
And that allows us a little bit of a personal touch. If you want to reach us, our phone number is 732-613-8000. Our website is www.sgklegal, and my email is Larry@sgklegal.
Nice and simple. Good. Right. Short. Yeah. That's great. That's one of the advantages. If you call Larry, I think if you call your firm, you're going to typically have the legal secretary. They'll speak directly to the attorney, which in this case is Larry. So that's invaluable to have that direct attorney oversight.
Absolutely. I think the lawyer office and some medical group, right, in my opinion, in my opinion anyway, is a different. Because when I remember when I was pregnant, right, many years ago now, so it's almost 20 years ago. At that time, I chose a group. They have 4 doctors, right? So in case if you need something, there's always doctor there. But with the legal, I prefer with the, like your guys, right? Yeah. The smaller firm, but I can get to the attorney because the attorney will be familiar with the case and always on top of the case rather than go through one person to another. A lot of legal secretaries, that's really the good point to have a very, very experienced and a committed attorney to help you when you're in need. Absolutely.
Yeah, I think experience is key. Larry, how many years have you been practicing law? Without giving away your age, right? You can approximate it, right? But long enough to be experienced.
How about this? I passed the bar in 1991.
Wow.
That's that's not that long ago.
Yeah, when did you pass your bar?
I don't want to. I passed my bar in 1992, so we're
you see,
so
you're both similar.
About the
age.
same time. Yeah, now we date ourselves because everybody could say, well, after college you're 21, and then if you go right to law school, 3 years, so that means you were 25 in 1992 or whatever. But, so this show is going to focus on real estate. So let's talk about to skim the surface, why it's important if you're doing certainly any commercial transaction as well as residential real estate transactions to have a attorney represent you as both the buyer or the seller. Let's talk about the vital role the attorney plays.
The attorney in a typical real estate transaction, and you said residential because most people that buy and sell residential real estate may only do it once or twice in their lifetime. They have less experience. And the job of the attorney is to act as the legal advisor throughout the process. Once a contract is signed in a residential setting, the attorney then handles the attorney review and negotiates any changes or amendments that are required to protect the client's interests. Sometimes there are specific nuances to the transaction that you need to make sure are properly documented, and negotiate. Then once the contract is done, deal with the legal side of inspection issues as opposed to the real estate side.
The emotional side.
The emotional side, or
as well,
you know,
but mainly legal side. Yeah.
talking to the lender, talking to the other lawyer, and preparing or looking at the closing documents. The idea is to identify any problems before they happen and solve them, and to make sure that the client really understands what they're getting into. Buying a home is typically the largest single financial transaction anyone is going to get involved in, and one that for the typical buyer has a 15 to 30-year tail when you talk about the mortgage.
Yeah.
And you want to make sure that your interests are being protected.
Yes,
Right.
absolutely.
Yeah, that's a great overview. And their interests can be with the contract terms, could be with the home inspection rights, also title. I mean, that's something that I think a valuable role that the attorney plays is making sure that the title is clear, that there's no liens, encumbrances. I mean, I know the title company does that to some degree, but having that oversight of somebody like an attorney with the legal expertise is vital. That's just so important, and to make sure you're protected, and then reviewing and preparing the closing documents, or making sure that they're properly recorded and the liens are discharged. There's so many things an attorney does that for even anybody to hesitate to proceed without an attorney, I think is very short-sighted.
Yes, ironically enough, most people south of the Princeton, Toms River line don't have lawyers.
Yeah.
Which is interesting. New Jersey has two separate.
So almost like the Phillies side. It's almost like the fan base, like the Phillies, the ones that go to Philly and the ones that go to New York.
If you root for the Phillies and the Eagles,
you
in
probably
South
don't have
Jersey,
a lawyer.
They don't use attorneys primarily, and if you root for the New York teams, you do.
Yeah.
But it's New Jersey is very unique and strange in that respect, that in the northern half of the state, attorneys in real estate are ubiquitous.
Yeah.
In the southern half of the state, it's sort of the exception rather than the rule.
Yes, I agree.
Yeah. So let's get back. You touched upon attorney review. There's a lot of misconception among the buyers and sellers about the attorney review period and the 3-day rule, and that it has, some people say like, oh, after 3 days the contract is binding or the attorney review must end. But that's all. Just so you can let's clarify that.
Attorney review is confusing. In New Jersey, the process of negotiating the real estate contract for a residential real estate contract, it's backwards. You sign first,
and then you sign
then you negotiate. So people will come to me and say, "Well, I don't want to sign until
that happens.
I've negotiated the deal."
Especially New York buyers,
New York
right?
buyer refuse to sign.
Because they do things differently.
And I tell them in New Jersey, you have to sign first.
Yeah.
The attorney review period doesn't start until the contract is signed.
That's a good way.
And some people, as you say, they have trouble wrapping their head around it.
Yes.
But what happens in New Jersey is that once you sign the contract, and typically this is when you're working with a real estate agent, you use a real estate form contract from your
Standard,
wherever your brokerage is, and then you give it to the lawyer, and the lawyer opens review. So what is attorney review? Attorney review is merely the negotiation of the terms of the contract. Under the New Jersey law, you have 3 days after you sign to open the review period.
Yeah,
doesn't mean you have to finish in 3 days.
And those are three business days. So not counting weekends or legal holidays.
3 business days to open the review period.
To find the attorney. But having said that, I'm
in other words,
to fire,
but to fire the missile, in other words, either the buyer attorney or the seller attorney must within that 3 business day period fire a letter of proposed changes. If otherwise, if that attorney review period lapses without any response from either attorney, then technically the
Correct.
contract.
So if
Funding.
right,
Yeah.
if neither side was technically you send a letter disapproving and terminating the contract.
Yeah.
So the language sounds very scary.
Gary, but
The letter then goes on to say, but if we incorporate these terms, we will reinstate. Again, it's legal terminology opening the negotiating period to resolve these various issues. And, by way of example, typically there are terms that the agent, one of them may write at the end of the contract. Depending on the form, it's either paragraph 41 or 42. And I look at that one first because I want to see if there's anything.
the additional
Me
provision.
too.
Correct,
Yeah.
the additional provisions.
Right,
so,
right.
so sometimes it'll say something like house is being sold as is, no inspections. Or it'll say, buyer is willing to give a concession. So those things, although they're in the contract, have to be properly framed.
Yeah.
Or sometimes other things come up during the course of the review that we need to address in an attorney review letter. So you have 3 days to open review, but while review is open, either side can terminate the contract for
Yeah.
any reason or no reason at all. So you do want to get out of attorney review as quickly as possible.
If you're a buyer.
Yeah.
well,
Seller doesn't have the incentive because the seller could get a higher offer and they
Correct.
decide they want to
Yes.
just keep.
although in a buyer's market, I guess if you get a deal, you're
That's
happy.
right.
You're happy to get a deal.
Yeah, right.
At the
That's-
moment, it's seller market still. So I think if you're a buyer, get out as soon as possible. But when the market turns, when it's a buyer's market, I think seller will be so anxious to end the review too.
And one of the reasons why attorney review is so important in the residential setting is because, as I said, typically you're using a form contract.
Yes.
And although one size fits most, one size doesn't fit all. So you have to tweak that form to reflect the particular circumstances for that transaction.
Okay. All right. Well said. We're going to go to break. We'll be right back after these messages. Please stay with us. Okay, welcome back to our show. We're joined this morning by Larry Kroll, a partner with SGK Legal. And Larry, once again, please give your contact information for our listeners out there.
Certainly. My phone number is 732-613-8000. Our website is www.sgklegal.com. And my email is larry@sgklegal.com.
All
That's
right.
simple.
Thank you
That's
very
good.
much. Yeah. So let's conclude with the residential contracts. We were talking before the break about attorney review, how it must be initiated within the 3 days, and then the attorneys go back and forth with proposed changes, and then what happens when attorney review is done, how that ends, and then the contract.
So typically what happens is the parties agree on the terms, the clients authorize the attorneys to sign the final review letter, and then you have one single integrated contract that consists of the initial form as well as any attorney review letters that may have been shared back and forth. And once the last addendum letter is signed, then you have a binding contract.
Yeah.
And from that point forward,
You go through.
we work towards closing. As you said before, we look at inspections. If there are inspection issues, that, frequently the real estate agent gets involved very heavily in those. That's one of their areas of expertise. When you work with professionals like Ken and Jane, they're they're very good at that. When there could be title issues,
Yes.
people don't. There's a that's a whole separate conversation.
So we could spend an hour
but
on
just,
that.
But there's a misconception. I mean, title protects your ownership interest. If something
right.
happens that challenges your ownership, whether it be an unfound easement or a fence that's on the wrong side of the line, or
happened.
somebody that says, "Wait a minute, my great great grandfather never signed that deed. That's a forgery. That's my house."
Yeah.
Those are the kind of things that title is designed to protect.
Yes.
And in the process, we do look at whether there are open judgments or other problems that, open mortgages that could impair your ownership and deal with those.
Yeah. So, so the role is quite a bit of steps that the attorney's involved in. Now, let's switch gears. Even a lot of agents in the field that don't do commercial real estate even ask me the question. There's confusion with commercial transactions, it works differently. In other words, there is not a pre-printed contract that's filled out by the sides. There's something called the letter of intent that's agreed to, which is a non-binding kind of a proposal about the terms, the purchase amount, deposit, closing date, due diligence, zoning, just trying to outline, and then that's given to the attorney, and then you can take it from there how the attorney goes ahead and prepares the commercial contract in a buy-sell.
So commercial real estate contract works more traditionally in that you negotiate the terms up front
Yep.
based on the letter of intent or memorandum of understanding, whatever it is that the parties enter into, which does outline in general what the terms are going to be. Purchase price, due diligence, and typically in a commercial setting, you're dealing with much larger pieces of land, you're dealing with much larger numbers. The loans are quite complicated sometimes, and there's a lot of due diligence that takes place even before you enter into the contract, looking at financials or looking at other issues that you want to address before you sign the contract, and that then sort of rolls into the negotiation of the contract itself. And again, that's much more traditionally done in that you negotiate all the terms, put together the final paperwork, the final contract, and then the parties sign off on it.
And that applies for both the buy-sell or for rentals too.
For lease.
For lease as well.
Correct.
Yeah.
I mean, sometimes a commercial lease can, in complexity, approach the involvement that you get in a purchase transaction.
Because you get into things like the tenant improvement, the landlord improvement, the rent abatement, those things. So in other words, with commercial transactions, I think it's fair to say that the negotiation process time period can be lengthy. It can drag on. From my experience, at least, it can.
It's not uncommon for the negotiation process before you even sign a contract to go on for months.
Months, right.
It could be, depending on the nature of the transaction and the extent of the due diligence that you're going to do, it could be 6 months before you even get to sign the contract. And then the lead time after you sign the contract, traditionally in residential, once you finalize the contract, you're looking to close usually within 90 days I'd say the vast majority of residential transactions take place. In a commercial, to take 6 to 12 months to close is not unusual or uncommon, because then there's a whole host of due diligence and investigations that you do afterwards.
Right.
Correct. Environmental being maybe the single most important because of New Jersey's environmental laws, which are quite strict.
Right. That's what we always say. Residential is the short, quick, but commercial, you're in for the long haul, right?
Yeah,
that's why a lot of agents don't want to do commercial because it's tiring. You need a big pipeline, a lot of stamina to stay in a commercial deal, right?
And you need a lot of more knowledge too. For example, when I started 16 years ago, I got a commercial kind of certification from co-op banker that time I worked for. And as a commercial agent, I went to special training, got a certificate, certified, and everything else. But I never, the commercial side business never pick it up because that's take a long time. It's a lot of knowledge, a lot of involved.
I went through the whole training to become a CCIM, which is Certified Commercial Investment Member. So there's a lot of numbers. A lot of it comes down to with commercial people. If you're investors, they're concerned about the net operating income, the cap rates. So it's a lot more numbers driven, a lot more technically driven with environmental due diligence, numbers. What's the bottom line there? It's not so residential is also numbers driven, but there's also the emotional element. A lot of the falling in love with the house, first time home buyers. So, but it's a different mentality with commercial.
And you guys have to work a lot with the township too.
And there's a zoning,
like a zoning, everything.
It's
a lot of work for the lawyer.
Not only zoning, but also change of use. You could be zoned. It's very complicated with commercial. You could be zoned for different usage in a strip mall, but if you're changing the use from use A to use B, it still could trigger an issue if there's not enough parking. Like if it's zoned for events planning, but the previous use was maybe, I don't know, a deli, and you want to bring an events planning there, even though it's zoned for it. But if you don't have the parking or the number of bathrooms it gets very complicated.
Correct. It can get very complicated. You also run into things like corporate governance, where you have to make sure that the company is properly set up, that they've paid their taxes, because you get involved in tax clearance issues with the state of New Jersey. You have to make sure that whoever the owner is authorizes the transaction. So there's, in addition to the real estate, there is some corporate governance things that you have to be aware of that take time. as you said, the environmental is very stringent. New Jersey's environmental statutes are what's called strict liability, meaning if you own or rent a piece of property, even if you were not involved in the discharge that created a contamination, you're still obligated to clean it up.
Right.
So that's why the environmental investigation is so important in a commercial setting.
Right. And they have something, Larry, that's in the commercial field that's called the innocent purchaser defense. But to qualify for that, you have to make sure that who's ever the buyer, they can rely on the phase one report. So if you're having a lender involved and the lender orders it, you have to make sure that the buyer, the buyer has the right to rely on it so they can claim the innocent purchaser defense when they buy, right? You can, I'm sure
you're correct. It's, it becomes very complicated.
Yeah.
And then as you mentioned, zoning sort of doved back, towards leasing as well. But you may want to rent a particular space for a particular use, but the other leases in that location may preclude that use.
That's
there may
true.
be exclusions
Yeah.
in the leases, so you have to make sure that you check everything else.
Or
so
the
that,
anchor tenant,
correct.
like whether it be a Starbucks or a Dunkin' Donuts, they may have a broad
Right,
exclusion that they say we don't.
One of the
so-
common ones is we can be the only food service in
Yeah.
this location.
Yeah. So
So if you're a pizza shop
Yeah.
and the bagel store wants to open up next door,
Yeah.
you could have a problem, even though you really don't serve the same market and you're not open at the same time. So
Yeah.
that's also the subject of a lot of negotiation sometimes.
right. So it's
I think with a commercial, the number one thing is to get you the best knowledgeable commercial and the agent and a commercial attorney. Because when I was a newer agent, like they call residential or commercial and a residential.
Oh, a mix, a
Agent do
hybrid, like
both, right?
yeah.
I mean, anything with a commercial, please stay with the agent, have more experience in commercial. Like I said, 16 years ago, I'm certified, but I didn't jump into it because there's a lot involved, just as you
and
said.
same with the attorney. That's why you have to go with
You want a
somebody
special
like
attorney. You don't want
somebody
any
like Larry.
attorney.
You want to go with somebody who does commercial because a lot of attorneys may only do residential, amongst other things. Not to knock them, but commercial is its own field. So you really
Yeah.
need to know somebody who
Absolutely.
knows the landmines.
And working with a experienced, knowledgeable real estate agent is key. When I get a transaction in, whether it be residential or commercial, I'm always looking to see who's the agent involved.
So yeah,
No,
idea
true,
what-
because I know that if it's someone that does this for a living, this is how they, this is their primary job as opposed to somebody that does it on the side, let's say.
Yes.
They understand how to get from contract to closing.
Yeah.
They understand how to assist the client in getting inspections taken care of. They understand, on the date of closing, I know, an experienced agent knows how to pick up the phone and get someone to clean. Or in the rare experiences, grabs the broom and cleans the property up themselves.
And we had to help
Correct.
oftentimes the commercial agents have to help the attorneys with like the Oprah request, like getting a copy
Right.
of a variance that goes back to 1980 for a particular property.
And I very much appreciate it because when you have a dedicated and experienced team of professionals, everybody knows what their role is. Everybody works seamlessly together to get from contract to closing. The only difference I'll say is that the agent typically wants to close every deal. And I sometimes look at my job as saying there's the 0.1% of deals that shouldn't, for whatever reason.
Sure.
And my job is to make sure that the client is taken care of and that if that deal shouldn't close, maybe something comes up midstream in an inspection or a title issue or something happens. There are, on very rare circumstances, but there's the deals that just, it's not in the client's interests to actually get to closing.
I agree with you
Yeah,
100%.
you're right. You have to do
if
its best.
anything, you have a doubt, stop
Right.
there.
Yeah.
To
And-
resolve it.
And
yes.
I sometimes find an experienced agent understands that.
Yes,
And
absolutely.
an inexperienced agent will pick up
Once
the phone and call me and yell at me, why didn't this deal close?
because they're anxious.
You
They're
can't.
thinking about the
They're thinking
bottom.
about-
They're thinking
correct.
about
You
have to protect
right, but
your
you
client.
have to. You don't even think about that. That's like an ancillary effect. If they close
Correct.
it, they close it. But you have to think about
Once
going
you
through
close,
that.
you're
It's a pro-
done.
You're done.
Once
Yeah,
close, you're
you
done.
Just focus on the
you have to
success and
worry
what's
about your
the
clients.
best interest of the client.
Yeah.
Right.
Hey, we're almost out of time, but I want to just touch upon another area that you do that's very important, which is landlord-tenant. We have about a minute and a half. If you could just give a pitch for,
Very
for
quick.
more.
Well, we should be here an hour.
We should have been an hour, but you can't really talk about it
Very
briefly.
quickly, landlord-tenant in New Jersey, there again is a very big distinction between residential and commercial. In a residential setting, there's very strict guidelines on when and how and why a landlord can evict. Obviously, non-payment of rent is the biggie, and you don't need to put the people on notice. But the other ones are, if you're being disruptive, if you're not following the landlord's rules.
Yeah.
But you have to place the tenant on notice, and there's a whole eviction process. You cannot do it yourself. In a commercial setting, there is guidance, but it's not nearly as strict. And you can evict a commercial tenant for a variety of reasons. You don't have to comply with all of the same notice provisions. In some cases, you can actually just lock somebody out without even going to court. It's rare, but you can do it. Which, if you do that in a residential setting, it's called a felony, and you can go to jail. So we try to.
I don't recommend that.
I wouldn't recommend that at all. But yes, there is a process. In order to get possession, you have to go to court, file for an eviction, get a judgment for possession, and then a court officer will go conduct a lockup.
And that has nothing to do with the monetary end of it, which is confusing to the layperson. True, there's eviction, which gets them out if you go through the process for landlord-tenant law, but then if you want to try to get a monetary judgment for whatever the back rent is, that's a whole different court and a whole different filing.
Correct.
Right? So
in residential, you have to evict first and then file for the collection. And although you can get money in landlord-tenant court, that would be in lieu of the possession. If the court, if you pay what's due, the case is dismissed.
oh, they'll give it a stay at this.
Right. Well, if you pay the outstanding rents that are due and owing, then the tenant gets to stay and the case is dismissed.
Yeah.
But if you don't pay, then the landlord gets what's called the judgment for possession. All that does is allow you to re-enter the property. Court officer goes and locks the people out. You then have to file a separate action to collect the outstanding rent.
Right.
In a commercial setting, you can do them simultaneously, or you can do them backwards. I've actually sued people for collection and not tried to evict.
Yeah.
But
Yeah.
Again, there's
but
a
it's
whole
it's a whole process, and we
Correct.
could spend a whole
Call
half hour.
Larry.
Call Larry.
With
Larry,
your
thank
case.
you so much for being our guest. You're the one stop for all your residential, commercial needs, including landlord-tenant. That's what we want to convey, as well as doing your other probate and general litigation matters. Larry, please give your phone number one last time, and thank you so much. We're almost.
Thank you for inviting me. I appreciate it. 732-613-8000, www.sgklegal.com. Larry at sgklegal.com. Thank you, Jane and Ken.
Thank
Always
you.
enjoy working with you.
Thank
Same
you.
here.
Same here.
Thank you.
Have a great weekend, everyone. See you next week.
Thank you.
Thank you.